Employees who don't follow regulations outside of work could face disciplinary action. The Occupational Health and Safety Act confirms that employers are required to create a safe working environment which could mitigate the spread of COVID-19. For more on this, we're joined by employment practice and labour law expert Michael Yeates from Cliffe Dekker Hofmeyr. Michael, very good morning to you. Let's talk about how you could be punished for how you behave outside of work.
Hi, good morning. Yes. So it's a long-established principle in our labour law that if you are found guilty of conduct outside of the workplace and if there is a sufficient link between your extramural activities and your workplace, that your employer can take disciplinary action against you if those activities do have a negative impact on your workplace. A simple example to use in this instance is, for instance, the use of social media, where if you are at home in your leisure time, outside of working areas, and you post some form of derogatory or racist comment on your social media page, if that social link or communication can be linked or traced back to your employer can then take disciplinary action against you for bringing it into disrepute. So
so how does it play out in the COVID scenario?
So in a COVID scenario, for instance, if you are wearing a corporate uniform or something of the sort and you walk around in public without wearing a face mask, that could, for instance, bring reputational harm to your employer, or even more opposite in South African's context. If you are traveling on public transport, for instance, and you remove your mask, it is possible that a co-employee who's using the same public transport could, for instance, raise a grievance with your employer in that you are exposing yourself unnecessarily or recklessly and unlawfully to potentially contracting COVID-19.
And if you behave that way, what you could be taking back into the office with you. Okay, let's find out then what the employer needs to provide in order to make sure that the environment that the employees work in, the well-behaved ones, are safe.
Yes, that's correct. So of fundamental importance would be that the employer would need to draw or show that causal connection between the outside activity and the impact on the workplace. It's not good enough just to suspect. There has to be some good evidence to show that you flouted the COVID-19 regulations and that you are potentially impacting on the workplace by bringing COVID-19 or potentially bringing COVID-19 to the workplace.
All right. So, I mean, what is the punishment then? I mean, what's the legal framework around it? Is it just suspension or being fired? And if the employer doesn't comply by providing adequate safety, what's the impact on them?
So it depends on an employer's own internal policies and procedures. And obviously, each case would need to be dealt with on its own merits. But the appropriate sanction can range from anything between a written warning even to a dismissal, given the circumstances of the facts and the extent of the recklessness. You also take the employer's own circumstances into account, what type of job the employee does, the level of exposure that employee may have on the operations, and what a potential infection could mean for that employer in those particular situations.
Okay, and so if the employer is not providing adequate safety measures at work, what could the employee do?
Well, if the employee feels that the employer is not providing enough regulations or at least safeguards at work, the employee could refuse to attend work until the employer addresses that, or the employee could, for instance, raise a grievance with his employer and expect his employer to deal with that, or the employee could even go to the Department of Labour and raise an issue or a complaint with the Department of Labour.
All right, Michael Yeates, thank you very much for that.